This is an application for the decision of the summary judgment granted by my father, Dr. J.A., on the 28th of August 2030, in terms of which the applicant was ordered to pay the sum of 1,45638.87 interest thereon and cost. This application, the third application brought by the applicant for the same purpose. The two previous applications were dismissed because no case or sufficient cost was shown for the relief assault. This present application is also opposed by the first respondent. In opposing this application, the first respondent filed an opposing affidavit proposed to by one Shabisa, in which heading of the affidavit reference is made to parties who are not involved in this matter. The applicant took issues with this, and in my view, correctly so. But I am of the view that this is not fatal to the affidavit that the respondent has filed. And for this reason, I condone such errors as they may appear in the affidavit. In order to put the application in its proper perspective, it is apposite to briefly look at the history of the matter. During April 2013, the first respondent instituted action against the applicant for payment of monies together with an order declaring the applicant's property executable. This action was suspended, and the applicant instructed attorneys who on his behalf entered appearance to defend. After appearance to defend was entered, on or about 16 May 2030, the first respondent applied for summary judgment against the applicant. The applicant in the interim changed legal representatives, and at that stage was represented by a firm of attorneys known as Lidless and Lidless and Associates. Lidless is spelled L-I-W-D-L-E-S and Associates. After postponement, the matter was set down for hearing on the 28th of August 2030. On this day, there was no appearance for the applicant, nor was the applicant himself present. As a result, and in open court, the Judge President of this division had the application and gave judgment as per the court order. Subsequent thereto, the applicant brought an application for the decision of this summary judgment, and it is not apparent from the papers filed of the court in terms of which rule or whether it is in terms of the common law that this application is brought. It is tried law in an application for the decision of the summary judgment, especially under the common law, but where the court has considered the merits of the dispute before summary judgment was granted, decision can follow only on the limited ground of false fraud, dispute error, or under certain exceptional circumstances. For example, where new documents that is discovered that contradict those that were put before. It is furthermore tried law that where the court has considered answering affidavits or evidence before granting summary judgment, the court court will then have to consider the merits of the case in its judgment, and this judgment cannot be held to be by default, even if there was no appearance of the defendant when the application was held. It is my view on reading the papers filed by the applicant that no case for rescinding the summary judgment has been made on either the grounds of fraud, business error, or exceptional circumstances as may justify such decision. Instead, the applicant has made disparaging remarks about judges of this division as well as the administration of justice in general. I am of the view that it is not necessary to recount these allegations. The contents thereof are on record, with any interested party may refer to the papers filed on record, if such party is reported to do so. The Constitution of the Republic of South Africa makes provision in Section 34 for the adjudication of disputes. This it does so in the following terms, and I quote: everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before court, or where appropriate, another independent and impartial tribunal or forum. This important right has with it corresponding obligations on the litigant. The litigant is expected to abide by the rules of the court or the forum in which to bring such a dispute for adjudication. The applicant in this matter has shown a blatant disregard for this rule and wish to conduct himself in the proceeding in this court on his own terms. This cannot be condoned by this court. Countenance such conduct will create uncertainty which will bring administration of justice into dispute. The applicant, like all other litigants who appear before this court, is bound by the rules that apply in this court. In the circumstances, I am not satisfied that the applicant has made any case for the decision of the default judgment, the summary judgment under this. The applicant has brought two previous applications where the rules of this court were not followed. It is for this reason that the first respondent has requested that this court grant punitive cost order. I am of the view that time has arrived that this court express its displeasure in the conduct of the applicant by making an appropriate cost order. In the circumstances, the order I make is the following. The application for rescission of summary judgment is hereby dismissed. The applicant is ordered to pay the cost of the application on an appeal and client's fee. 13. Save for an application for leave to appeal this order, the applicant is barred from bringing any further application in the matter under case number 5126 of 2013 without first applying in writing and obtaining the leave of the judge president or the deputy judge president of this division.
Should we go upstairs?
Yes.
Okay.
Sorry, will I get the court order?
I don't have any copies, so I didn't bring anything.
Okay.
The artist and I searched for a copy of them. I don't have a copy of No, them.
Okay, but you're doing it today, writing out the court order?
No.
That's what I was doing now, so you heard it. That's
basically, if you want a copy, You can ask downstairs, you can request them to sort a copy
And
out for you.
where's the original being held?
So there is no original.
Well, there must be an original court order.
Judge Preston in handwritten notes.
Yeah,
But that's the original.
that's the original.
No, that's not the original. Don't get me wrong. Judge Preston, it's an extemporary judgment. We Judge Preston.
Okay, but it must be filed on record as an original somewhere.
There is this copy. I
It's
cannot
not
see
for
this
written
matter.
reasons, but this is those are his reasons. So it's just a case of whether you have it on the page or whether you have
Okay,
it in your
so
head.
in other terms, the last court order is still valid, the one that was issued by Judge President hlophe.
This is you brought an application for rescission of that.
Yeah.
So this is you had dismissed that application.
Okay, so the old court order still stands,
Yeah.
the one that got conditionally accepted, with changing tides or Villian Tinder's stamp on it.
Yes.
That is on file,
Yes.
and the conditions have not been fulfilled.
What condition?
Thus the auction is fraudulent, because it's on file, it's in the file there. The original court order was conditionally accepted within 72 hours after the 28th last year.
What do you mean it was condition?
It's an order, you know, an order
Yes.
is an offer. Law is contract, contract is law. I conditionally accepted it, I served on Villian Tinter, they accepted it, they stamped it, I've got a certified copy.
But what do you
And
mean you accepted it? You accepted a court order.
Yeah. I can either accept it with...
I don't think you understand.
I need to break you. I have an appointment at office now. If you wish to have a copy, you need to speak to us stenographers downstairs.
Okay.
And they can arrange it for you. I do not have a physical copy for you at this time.
Okay, and who's the stenographer?
You can speak to Mr. Muhammad Mia.
Mohammed Mia.
Yes.
Okay.
You can speak to him. At this stage, I do not have a physical copy for you.
Okay. All right.
Thank you.
Thank you.
Mr. Dalma, listen, I'm going to do this. Let's number is 5123. Because there were two case numbers. You only can look 5123. Hand it down.
No.
Hand it down.
You know, I thought I still him today, you know. If he was under oath today, if he recited the Bill of Rights, yeah. But was he under oath? Should have hold it.